you don't have mental capacity that equals no limited legal capacity. So that's the assumption that most of our laws have inherited from our colonial masters. We've adopted it, we've enforced it, we've embraced it, we believe it, we preach it, right? And then comes around the CRPD after a long period of consolidated wrongdoing advocacy to say no. Legal capacity recognition, the same for everybody, regardless of mental capacity. And this was a fundamental mind shift, and still is. We haven't gone beyond that as yet in many of our jurisdictions. And that's what this chat is about this morning. So, I would like to hear from you in your capacity, in your position, or perhaps in your country, maybe it's not something you work with, but how is legal capacity understood in your domestic system? What is this thing called legal capacity? Not what should it be, what is it in your law? How does it look? How does it taste?
I think in most of the countries in the region that follow the modern tradition, legal capacity is the ability to be recognized as a person in terms of the law, which includes the right to own property, to make decisions, to make legal decisions for yourself, to enter into contracts, to marry, to buy and sell, all of those things, and even to be able to institute proceedings in your own name, in court, to defend, etc., etc.
Okay, so that really is what legal capacity entitles you to if it's recognized. So that's an excellent summation of all the ways in which it travels into life.
Thank you. So I was going to say that in the Zambian context, we have a similar understanding of legal capacity. And of course, in the Disability Act of Zambia adopted the CRPD perspective of legal capacity. And you see that Section 8 actually does affirm that all persons have legal capacity, regardless of their mental capacity. But in 2019, when we enacted the Mental Health Act, which the confusion started, because now we have the recognition of legal capacity, but also it's conflicted with mental capacity, the same Section 4. This is a matter which most of you may have read over in our cases are went up to the courts of law, and unfortunately, like you have explained, we haven't gone to the point where the courts would appreciate the right appreciate. And that's up the danger we have now in Zambia is that post 2019, all the laws being made about referencing the confusion of the remedial act around legal capacity. So we are trying to see how that can be handled. So yes, we still have the old common law perspective of legal capacity influencing our decisions. But when you look at the statutes, there was a to try and align ourselves with sharing. But I think that the understanding is very complicated. And unfortunately, jurisprudence is not very positive in that light, but we're hoping that we can get that resolved through maybe amendment to the existing Mental Health Act. So Zambia has attempted to move in the strategic direction, but in practice we are struggling and we are causing confusion in the nation. I think there's an example given yesterday by of how now people are getting to court and getting these orders around supported support persons that are not guided by strategic standards. So it's that potential for abuse already manifested in the application.
Thank you. So that is a cautionary tale. I mean, we think that an incremental approach is going to take people with us, but then we reach that very same stumbling blocks, which is that terminological confusion. And of course, the interface between the medical profession and the legal profession. And we have very much really been resistant to move away from understanding legal capacity as separate from mental capacity, and not identifying that limitations in mental capacity may mean that you require support in order to exercise your legal capacity, not to deprive it, right? So that's that starting premise of the CRPD, and you'll see today that the disability protocol for us is very much on the same thinking process, but even though we are at the same thinking level, those pushbacks are still there. So it's hard because in South Africa we also have a mental health act which has been lauded as a human rights instrument, particularly by the psychiatric community. Whereas one of the examples is we've come so far from where we were, and indeed we have. We must acknowledge that. But we haven't come far enough, right? So we're going to give a couple of examples today of just how much further we need to go on this journey. So another question I want to ask you is, when you're looking at the limitation, restriction, deprivation of legal capacity in your legal system, what does it look like? So you're not quite at Zambia's level, maybe, where you have a regime that acknowledges the need for support. Maybe you're not there yet. What does it look like? So we can talk about a mental health perspective, or you can give me an example from fitness to plead or to stand trial, or you can give me an example of procedural rules and any other opportunities that you have to share with us. What does that limitation look like? So if I'm a person with, if you want to call it mid to severe intellectual disability, and I am in your legal system wanting to have one of my rights recognized, open a bank account, marry someone, access mental health treatment. What does your legal system do for me currently? What does it say to me about my legal capacity to make these decisions? And I have a perspective from Kenya.
I just want to pick up on what you say about opening a bank account, because we have an ongoing case for a petitioner who wanted to operate a certain account in a certain bank, but based on him being visually impaired, the bank indicated that he has to give out his forward, and if not, he should sign to indemnify the bank from any that should happen to him and his accounts, based on the fact that he blocked, of course, sending a forward. And it's an ongoing case. We are actively on it because apart from it capturing challenges of what legal capacity is seen to be, it cuts across all disabilities. So, of course, as I mentioned yesterday, we work in an organization where we focus on intellectual and psychosocial disabilities, but you can see that even the act of operating and controlling your own financial affairs has hindrances. Consistent institutions actually think at this point we are advocating and include every person in the system. So in that defense, every people will say this, but in that defense, they have to say they are working on certain guidelines internally to see how they can ensure that it's inclusion. So yes.
So the pervasive nature of not recognizing someone's legal capacity because you see inability, you don't see ability out.
Usually with an application to the master to appoint a curator who will be responsible for the affairs of someone who is regarded as mentally incapable of carrying his or her own affairs. And on the society, they don't go the high court way. it's assumed and it's purchased therefore common that as a guardian or a parent, you assume the position to contract on behalf of the person who cannot or who is regarded as mentally incapable. Thank you.
Thank you so much for that. So we are substituting that decision making in the process, and we are appointing someone else to take on that role. Okay? And of course, when you do that, our assumption is that we can see the best interests of that individual. We want to protect the individual. We want to safeguard the individual and their interests. Where does the best interest principle come from, and where are we most comfortable with it? Child law, right? The CRC. Child law, that's where we're at. We've made big strides in trying to get the contours of what is the best interests of children. And of course, you can be a child with a disability who has equal capacity, but because you have the disability, you can also face restrictions in the decisions you make, what you eat, when you eat, what you wear, who you're friends with, who you have consensual sex. Oh, why do you not have consensual sex? Because you have disability. And then we come to the point of those professionals or people in your family network who are the agents that are now appointed to make decisions for you. They have different names, guardians, curators, plenary guardianship, but those are those place holders that take in the place of the person who lacks the mental capacity. Anything you wanted to share with us?
Thank you. Last year I had a case in the children's court, where the parents, both the mother and the father, had intellectual disabilities, and they had 3 children. And the social workers wanted to remove the children from them, just solely based on that because of their intellectual disability, they couldn't take proper care of the children. And the fact that the children wanted to stay with their parents seemed to not matter because they find us, even though the act says we must hear the voice of the child and what they want. So it was very appeal.
And Rita, what evidence did they bring? What did they put before you for me?
There was no abuse, none whatsoever. Because the parents depend on a grant, therefore they cannot afford the standard of living that the social workers thought should be adequate. So they lived in a backyard room, which was once a toilet. So bed and then a toilet next to it. So that was very offensive, even though it was clean, and that's all they could afford. It didn't matter to the social workers, it was just the children had to lose.
So the evidence before the court was that the grant is the reason why, because and then of course poverty, even though not just South Africa, but most of our legislation says poverty or socioeconomic deprivation may not be a ground which discriminate. And in fact, social services, social welfare in societies are very much established on the premise that they must make up for those deprivations that you have in space. And they must assist you to access the resources you need in order to improve your circumstances. But they're the very ones who say, well, we can't do anything. We won't do anything because you're not good at it.
That was my main argument, that you are the Department of Social Development. You must fill in where there are gaps. But they wanted to take the children to an uncle in another province. The kids didn't know this person, and even though the father was saying, "This is my uncle and I was abused under his care, I can't let him take care of my children," they didn't care. So I had to fight that they put in the measures to support the family.
It was a successful fight. So the children are still with their parents and are doing very well. They're better formation now. So I do a monitoring order to see that the social workers actually attending to them and helping them when it gets.
So our champion here deserves a round of applause. So today, my doctoral research looked at the same premise it was with the rules. And in those instances, the magistrates were not alive to the CLP and were not alive to the fact that good enough parenting is the level and that supports need to be put in place. There was no supervision or monitoring of the parenting skills or poverty alleviation efforts or therapeutic interventions, none of that. And the diagnostic prognostic thinking was, in each instance, relevant. If you've got an intellectual disability, therefore equals incapable to parent, and of course no legal representation, so there's no voice for the parents or the children, because the social worker is the champion for children's rights. Correct? But the social worker has his or her own biases, and they operate at multiple levels. And of course, the magistrate may also have his or her own biases as well. And then you ask yourself, all right, so thinking back to yesterday, that's social worker's report. Obviously, is probably written in English. Social worker and the family might be English speaking, but it's in English. It will be a couple of pages long. There might be affidavits or medical evidence or other things attached. And I'm just curious, I know the answer, but at what point was the report explained to the parents? And at what point, if you didn't advocate for cross-examining that evidence, and if you were just not alive to it, where you have it?
I'm sorry if there are any social workers in the house. I'm taking your advice of naming and shaming. So I've come to realize through experience that sometimes even the social worker doesn't know what's in the report. Cut and paste, problem issues. So I have set it up in a way that they read the report prior to the court appearance so that I can go through it with an amplifying glass. There are other issues, logistics. So there will be a social worker who initially deals with the case, and then when they decide it's a child in need of care, it's transferred to another social worker who will just give them a file, come to court, they don't even know what's going on in the case. So I fortunately used to work for the legal aid, so I have a good working relationship with them. So I will have attorneys appointed for the children, so that at least there's somebody who can thoroughly cross-examine the social worker. And because I can take a proactive role in the children's court, I make it my responsibility to understand everything that's in the report and to cross-examine. So I think I fixed the issue that way.
Right, so the 5,000 cases I looked at was in Natal of applications that had been brought over that 5-year period for the two courts. Legal representatives were appointed in 3 instances, and they were, because the case was referred from the divorce court to the children's court because there were allegations of sexual abuse that one of the parents made against the other during the course of the case. So that was already a pre-existing relationship with legal representation. And in none of the instances where the parents had psychosocial or intellectual disabilities, did the magistrates take any steps to appoint the representative, or ask them if they wanted legal representation. Or take up what the legislation is aimed at doing, which is an inquisitorial role, right? To say, we don't always need terms in the house, because we've got the magistrate. who is supposed to be objective and can ensure that if it's a vulnerable person before them, that they, if they cannot get a legal representative, they need to inquire, deliberation. And then of course leave there the fact that at the end of that whole process, you made a finding that either the children are in need of care and protection or they are not. And when you make that finding, consequences go. If they are in need of care and protection, they go and they probably face alternative care, further supervision. If they're not in care and protection, you can still supervise. Of course, if you forget, you still have a role to play. But often people will say, well, okay, and then not in need of care and protection, you go back and do that. I'll see you next time. And that oversight is not there. Over the family to provide supports, and of course over the social workers to check that they also have what they need to do their job. So legal representation really is a very important issue. And the agency and the advocacy of the professionals that are in the room to understand what the implications are. I think there was another learning opportunity to share with someone else.
Good morning. I think it's, you are touching the nerve. Because it's very important, basically there are people whose rights are not protected. And it is assumed that they won't understand anything. And as a result, their voice is taken away. Even though I'm in a different place as compared to Lisa. On Wednesday, I was dealing with a matter in the regional court, the criminal case. This man pleaded guilty of murder. He murdered not his wife, his girlfriend, with whom he has 2 children, aged 13 is the eldest, the youngest I think is 7. On the last occasion, after he pleaded guilty, we postponed the matter for pre-sentence reports, probation officers. On Wednesday, the probation officer comes with the report, reads it. I'm very curious with the report. I can see that the report talks about the accused person, which is the father, the children. It talks about the elder sister who was interviewed, that is the daughter of the deceased mother of the 2 siblings. That she has stopped her aspirations to go to school because she has to take on the younger kids and so on. So far as considering the impact. As a judicial officer, you have to look at the before sentence, or to look at the interest of basically the personal circumstances of the accused person, the interest of society, the seriousness of offense. And I think with recent case law authority from the Supreme Court, especially the case of state versus strategic, you also have to factor in the impact on the victim or the people around. Here I have a report which is supposed to be assisting me to amend the decision. This report is silent about the voice of these 2 children who are actually the center of these 2 parents. One who's deceased and the one who's about to be sentenced. Now ask the social worker, did you make any effort to talk about this kid? Check what's happening with this kid. Now the only thing you could report is that the 13-year-old is already displaying some behavior problems, smoking cigarettes, smoking they suspect his own stuff. I said, but have you taken the initiative to go down to the child? Or if you are not qualified, have you made an effort to get a social worker or a psychiatrist or a psychologist who can be able to conduct an age-appropriate interview with those children to get their feelings, to get their views, to know how they feel about the whole circumstances, and so on. In the process also, I realized that because the father killed the mother, whatever, these kids have already been delineated by the family, alienated from the father who wants to support them, but he can't support them because of the situation. So I'm here to intervene and say, I'm not going to make any decision. I want you to go back, get appropriate. I want to get the voice and the views of this children, the 7-year-old and the 13-year-old. I want to. That will help me to arrive at a decision so far as the impact on the victims. Thank you.
Okay, so you can also deserve a round of applause. So best practices need to be recognized and need to be championed and we need to talk about, because that is where we are taking on again more of an activist role than we originally anticipated in our job description. And we see where the gaps are, and we know where professionals are not meeting the required standard of care and the duty towards the client's population. So, and it is the same when it comes to the disability of a parent or a child as well. Or not just a parent, any person who is involved in the proceedings. So the preference, the information. What weights do we attach to it? How persuasive is it to us to act upon the voice of that child or the voice of a person with a disability? Not long ago, and still in many of our countries, the voices of women and elderly are still not amplified. And today we are talking about someone who could be a woman with a disability, or an older person with a disability, or a child with a disability. So that intersectionality can then also be highly problematic. And with it comes the assumptions. So when you spoke to me about the social worker, you said, this child has behavioral problems. Then you're writing off the child. That's what the social worker was doing. Was saying, well, now this child has behavioral problems. So, so the circumstances and my role is only to give this limited information but understanding the purpose of things. So, yeah, the tick box approach, I think, is also because sometimes our laws allow us to get away with it for too long because of the roles that it prescribes for the particular stakeholders in the process. You're an expert on mental capacity because you're a psychiatrist. What is your role? Yes, if you can get a report. Send someone for an assessment. They're on the meds. They're not going to be this person. And once they are in hospital, once you get the report, what happens with them, whose job is it? Is it the curator's job to worry about what happens to the person? Is it a legal representative if there's a legal representative? So many questions, all right. So I'm going to just take a pause on our dialogue and just go through a couple of concepts, and then we can take the conversation further. Right, so unfortunately, this slide is not an example of clarity, something wrong with the formatting, but it's all right. So ableism, which we all understand by now, the exclusion of persons by cultural imagery associated with self-sufficiency, autonomy, and independence. Self-sufficiency, autonomy, and independence. So the assumption is that if you can't do those things, then we need to intervene. We have ideas around able-bodiedness and able-mindedness. Saneism is very similar to ableism. The fact that we assume everyone must be sane at all times, and we have assumptions about what it means and your legal capacity when you are not falling within that box. So we can use ableism to identify laws explicit and sometimes implicit law in the oppression of persons with disabilities. And that is a tool for us as academics like myself and practitioners like you to contribute to unshackling educators' complicity and practitioners' complicity in the discrimination embedded in our legal culture and the teaching thereof and the precedent-setting nature thereof and the continuation thereof. So normativity is the value placed on the ideal colonized bodies during our colonial conquest. When disabled bodies and minds did not meet this ideal, they were normalized through firstly a charitable approach. It's civilizing, we are curing, we are rehabilitating, we are medicalizing disabled bodies and minds during our colonial conquest and apartheid in the case of South Africa. So the kind of examples that have come through yesterday and today talk to issues like fitness to stand trial, sanity defences, voluntary confinement, that's only the mental health sphere, and the criminal sphere. But today we've also heard that it also comes into family court proceedings when you're looking at parenting roles. You've heard that it comes from opening a bank account, being able to have access to your finances, to manage your finances. Okay? I was working with an organization that does business skills for autistic adults, and as part of this program, they accessed a grant so they could get a learnership with a stipend every month for the skills that they were learning, the vocational skills. And then you say to the parents and the young adults, you need your bank details. Parents say, sorry, what? My child, who is 21 or 25, does not need a bank account. What do they need a bank account for? I provide for all their needs. Okay, right, so what are we going to do here? Well, they can't just go to the bank because the bank won't assist. This young person doesn't have capacity to manage their own bank account. But we teach them vocational skills so they can do just that, so they can budget what they receive and that they can be participating in the way which they want to. We had to get an ally in the bank. We had to send all of our young students to that banker to facilitate the process of opening bank accounts. Because if you sent them to any bank around the corner, they would be turned away. And in fact, they were. So that was a DPO that was managing that process. They decided not to take the advocacy further than that because they attained access to bank accounts for their clients, right? So that was the end of that story. But what we want is, if you don't have support of civil society, or you have a family that is resistant to acknowledging the right to make decisions on the financial affairs of a person with intellectual, psychosocial, neurodevelopmental disability, if you don't recognize that they have a right to sexual reproductive health rights and decision-making, if you don't recognize that they have the right to vote, oh gosh, you don't really have a choice because your legal system will deprive them of the right to vote. Okay? So those are the consequences. Next slide, please. So what we wanted to do today is look a little bit at how the recognition of legal capacity impacts on the realization of access to justice. We want to unpack Articles 5, 12, and 13 of the CRPD and imagine examples like court rules being amended for procedural justice. And Dr. Masipa will talk about procedural justice a bit later, accommodations. And we're going to look at the law reform in Lesotho, what they've managed to do. And then I also want to make a link between the Life Visibility Challenge and also the Topaz case in Hungary, looking at deinstitutionalization, which is also very much part of the conversation around legal capacity and the role of the justice system in ensuring that we recognize people's legal capacity, because that enables them, it's an enabler to accessing other rights, dignity, right to life, freedom from torture, freedom from neglect, accessing your health care. Next slide. So, one of the challenges that we have jurisprudence, right? That in our role as developing the jurisprudence, we have this particular identity of what we're supposed to do. And it very much holds to the medical model of disability. It's paternalistic, it's mythologizing, okay? And if we are uncritical about how we go about using the therapeutic approach, it can be quite harmful. Of course, the therapeutic approach sometimes can be very helpful. In the United States of America often use the therapeutic approach, but also they put in place safeguards because they're not uncritical of the force and adoption of that approach. So when we're looking at reconceiving the idea of legal capacity under the CRPD and our protocol, very often what we're adopting is a critical disability studies approach. And this is interdisciplinary, and I'm sadly not social workers for today, because it's not just the legal profession, it's all the professionals involved. We need psychiatrists in the room as well. So it seeks to move away from curing disability and critiques the reliance on professional judgments of appropriate therapy for persons with disabilities, demanding instead that persons with disabilities themselves are in control of their own therapy, including the aim of that therapy to be curative, or to have another goal like breaking down social barriers. And we want to uncover this hegemonic framings of disability that individualize, pathologize, medicalize, psychologize, essentialize, and depoliticize the phenomenon of disability. So in South Africa, and I presume in other jurisdictions as well, there's a very heavy reliance on expert evidence. And if we are short of money, then we lament, oh gosh, I can't get an expert's opinion on this, right? Because experts know better than the person in front of you about the decision making. And then we still have incredibly offensive legislation on our books, like abortion and sterilization legislation, that again denies the legal capacity of persons to make decisions over their body integrity, and again imposes the decision-making ability on a panel of experts to decide what is to happen in the situation. Right? And you know what is so curious is in South Africa, we actually had a situation where children were not subject to forced sterilization under the legislative provisions. And then someone said, but gosh, we need to offer the same opportunity to children as well, so that we can also protect them. Let's see how we equalize things. So we're going to address the same discriminatory intentions of the younger population. And of course, who are we sterilizing? We're not doing large-scale vasectomies on young men, right? We are sterilizing young women and girls. And in my research in our province of KwaZulu-Natal in South Africa, we were also doing vasectomies on young girls. Not to prevent cancer or remove cancer, but to help their families and caregivers navigate the process of caring. Right? Or we would suppress their menstruation, etc., etc. Next slide, please. So, you already have an idea of where legal capacity enters into the courtroom. So it can enter through disability targeted laws such as mental health law, where we are concerned with people diagnosed with psychosocial illness or mental illness. We're looking at legal capacity law, like curatorship, primarily concerned with your particularly persons with intellectual disabilities, and then equal opportunities law, which is concerned often on people with physical or sensory impairments. So we need to equalize opportunities so they can also participate on the same basis. So that is where it comes in. And Quinn says in the mental health field, autonomy is the dominant value. Relevant law being animated by commitments to maximize autonomy through due process rights for legal capacity, protecting the person with a focus on substituted decision making, and if you're lucky, some safeguards, and for equal opportunities. Right? He says these different values, that's okay. These different values or ideals play an important role in separating the fields because the CRPD's drafting process brought together disabled people connected to all three fields, restoring the full panoply of values to each segment of the disability continuum. Thus carrying with it the promise of dissolving the boundaries that have traditionally separated different areas of disability topics. And I think that really is a beautiful encapsulation of saying just how strong the directionality of legal capacity is now. We used to think, that is something for the master's office to worry about, because they're appointing curators for people's property interests. No, that's for the psychiatrists to worry when families don't know what to do with this. Children. That's their worry. That's saying there's a social worker and a psychiatrist who thinks the person is a danger to themselves. They need to be confined to protect themselves or society from that danger. They have certified this is necessary. They need to be admitted without their consent. Right? Does the judge in chambers call upon the person, visit the person, pick up the phone and speak to, put on Teams or Zoom to hear the voice of the person who is deemed not to have legal capacity to make the decision? Or do they make the decision based on the documentary information in front of them, which I've seen, and many of you have also seen in your jobs? And what is it? A one-page document, right? It's a template. There's a couple of scribbles. A danger to himself. How did you ascertain it? I'm not saying it isn't necessary, but why do you say that? What's the diagnosis? What are the supports in the community? Is the person not currently managing the employment? What is the situation? What is the background? Who is this person? And where is his or her voice? No? Psychiatrist and the social worker agrees, so I sign off, and off we go. Right, so we are now, luckily, since 2007, and now since 2024 with the Disability Protocol, we have the legal tools to bring together criminal law, mental health law, and equality law, and really fundamentally different in our approach to the assumptions that we have, and the legal processes we put in place to attend to the discrepancies. Next slide, please. Just to reiterate, it's a discrimination law, it's a mental health law, including on when we institutionalize and send people to live in community-based living or independently. What do we do there? And then in legal capacity in relation to daily decision making or big decisions, voting, marriage, so a little bit more legal perspective. Our esteemed Coach Larker, who's from Australia, and Eleanor Flynn, who's from Ireland, they've written a lot about legal capacity. And they talk to the substitute decision making, and they talk to the fact that the process we put in place in our substituted decision making regimes, conservatorship, guardianship, curatorship, the process we put in place in effect silences the will and the preference of the person. Because we have assumed the righteous role of being the decision maker, right? And what we're doing in that process is that we're denying the heart of the individual and creating barriers to the exploration and the development of that individual's personality and being. Because when you can make small decisions in your life, it's really empowering and can help you make bigger decisions. It can also be incremental. But when you have a blanket approach to legal capacity and you deny it, then there's not just that particular legal instance that you are depriving the person from making decisions on. The person is now painted with this lack of an ability to even make decisions on daily living as well. So it becomes really a strong detractor from the agency and autonomy. Next slide, please. Because I mentioned the institutionalization, I wanted to just draw you to some of the guidelines that we have, and we don't have time today to talk about it in detail, but guidelines on the institutionalization, including in emergencies, 2022, and the impetus there was, particularly the COVID pandemic, made very clear. Countries did not want to do. We needed strong guidelines because the general comments weren't quite enough. We have the guidelines on the right to liberty and security from 2015. We have the general comment on living independently and inclusion in the community. And then, of course, the one on legal capacity, general comment 1, equal recognition before the law. So when we read those together, it really gives us a very strong idea around what state obligations are in relation to recognizing the legal capacity of persons we are supposed to deinstitutionalize, and the kind of supports we need to put in place. Next slide, please. So many of our jurisdictions have the idea of legal capacity. Often it's either status-based or functional capacity. This is how we make sense of legal capacity, okay? So we will assign the status of being legally incapable to a person, often through formal proceeding, like the guardian is appointed, or we will deny the validity of their exercise of autonomy in relation to formal legal acts or decisions where their consent would normally be required, and that is rationalized as not being legal capacity, but operating as functional capacity. That's where that conflation comes in between mental and legal capacity. And Tina Minkowitz has said that this distinction is nonsense. I love it when activists, lawyers, and academics are to the point. This is nonsense. Without an acknowledgement that legal capacity is validly exercised through the person's own voluntary acts, there's no equality in the enjoyment of legal capacity. It is true whether there's a blanket deprivation over a long period of time, or whether it only applies to a single act, whether the deprivation is pursuant to a court adjudication, or only the determination of a notary, banker, or doctor that the person lacks capacity to make a particular decision. It says functional capacity, which is being used to retain the binary system of legal capacity or incapacity, has a definite adverse impact on people with psychosocial disabilities, significantly as a rationalization for forced psychiatric interventions, which amount to ill treatment and arguably torture, and should be subject to an absolute ban, as well as with respect to the insanity defense or criminal imputability. Now, subsequent to her writing in 2012, indeed it has been established by various international bodies that this is in fact torture. So it's no longer a question, it's no longer arguable. Next slide, please. So when you use those functional tests in your legal system, you ask if the person understands the information and then if they have the capacity to act upon that information, right? So that is the functionality as to whether they have the ability. So one of the underlying premises also for legal capacity in my argument is this attachment of the label of vulnerability. So the premise is that we can use vulnerability as a protective label to ensure the best interests of particular persons. So we will use it in sexual offences where we have an aggravated circumstance. If you commit a sexual offence against a person with an intellectual or a psychosocial disability, we will protect the person when we sterilise them without their consent. In the traditional courts, of course, we don't have the same legal incapacity laws, but we tend to substitute it by asking the parents to give evidence on behalf of the child or other family members, usually also an adult. And then curatorship, where the substitute decision making happens. Then we can deny it. Our court rules, in South Africa and other jurisdictions, let's just name and shame ourselves. Who still uses the words lunatic and imbecile in their court rules? Which countries? South Africa, Zambia, Botswana.
Shamefully so, eh? Imbecile, yeah.
Malawi, who else?
It is about create lunatic, mentally disordered, mentally challenged, and mentally ill.
And let me read the section 246 of the Criminal Procedure Evidence Act. It says, verbatim, no person appeared or proved to be afflicted with idiocy or mental disorder or defect or laboring under any imbecility of mind arising from intoxication or otherwise, where he is deprived of the proper use of reason, shall be committed to give evidence while under the influence of such malady or disability.
That's almost verbatim with the South African provision under the Evidence Act. So that despite Pyramids versus the Gambia, where the court said no, you can no longer have a lunatic act. You can no longer use these words because you continue to perpetrate discrimination when you utilize these words. That was the early 2000s. We are 2024. We had lots of law reform initiatives in our countries at large scales, various aspects of life and relation. But we haven't deemed it important enough, even just cosmetically, to change these words to more acceptable terminology. Never mind the fact that the premise of the deprivation of testamentary capacity is problematic. But we didn't even think it is offensive to keep it on our statute books. Yes.
So in Zambia, we still have the Mental Disorders Act was repealed and replaced with the Mental Health Act that's Bruce and I think I also spoke to yesterday. That with the court case that we took from the courts, we challenged the use of those words in that case. And the court, I think it was the only ground that actually succeeded from all the other grounds that we raised on testing, the discrimination, violation of other rights like involuntary treatment. those reactivity or literature could be used in any studies. We still have a lot of those words in our Evidence Act, in our Criminal Procedure Act. So cosmetically, we shouldn't be used, but it's still on the statute, so statutory. Yes.
Thank you very much. Yes, in our country as well, we used to have a similar provision which are operating from Zimbabwe and out. But it was struck down in the case of George Davis, in which a member of the Joshua was able to challenge the constitutionality of that provision, which was now was alleged to have been late, and when the case was reported and taken to the prosecutor, the prosecutor today to take the matter to court on the basis of this section. So he then challenged the constitutionality of that section. Had one constitutional division whereby you can step down, so that means we no longer have such words in our legal system because of that case.
This is Lesotho, right? Hand of applause for Lesotho. So, Diana has written on the Shoshu case, and you're also involved in it at some point, yes? After the fact, well, that's still wonderful because the advocacy still needs to keep going. And Lesotho didn't leave it at the court case. The court rules were changed. So, we really have a movement in the right direction. Now, when we're looking at vulnerability, it can also be used as a marker for harm. And that's why our protected interests sometimes come out. The police brutality that is often experienced by persons with psychosocial and intellectual disabilities, or they can become a victim of it, like Daniel Julies in the Western Cape, who was a boy with Down syndrome, who was killed by the police. So you can understand the severity of the situation. He was just a bystander. Muti murders, particularly in relation to persons with albinism, hate crimes perpetrated against persons with disabilities, and then neglect, harm, vulnerability, and erasure that we experience in instances like life is intervening and the term as an institution in Hungary. Then we know that when we use this vulnerability label, we can also use it as a disadvantage, which allows legal protections to kick in, such as eligibility for grants, affirmative action in the labor or business field, and procedural accommodations, of course. So that's the flip side of vulnerability as well. But only really the last two, affirmative action and procedural accommodations, are instances where this vulnerability also acknowledges the agency of the person. Because it says persons with disabilities need accommodation or a positive measure to equally participate in the workplace. So we need affirmative action because without it, it's not going to happen. Or we need to put in place procedural accommodations because if we don't utilize them, then it is a deferred treatment persons not equally participating in the legal process because they have the agency, they have the voice to provide the support that they can give that voice, right? So vulnerability can be problematic, but it can also be quite empowering. Next slide, please. I'm going to ask you to go through a couple of slides because I want to look at the wording. Please keep going, 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 almost gone, going. There we are. Just go one back. So the CRPD, which you are very familiar with, I'm going to read through it because next I'm going to look at the African Disability Protocol. The states parties reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law. Okay. That even goes into space, it doesn't say on earth. Everywhere. States parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. States parties shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. Next slide, please. Vivi, next slide, please. States parties shall ensure that all measures that relate to the exercise of legal capacity provide for appropriate and effective safeguards to prevent abuse in accordance with international human rights law. Such safeguards shall ensure that measures relating to the exercise of legal capacity respects the rights, will, and preferences of the person, are free of conflict of interest and undue influence, are proportional and tailored to the person's circumstances, apply for the shortest time possible, and are subject to regular review by a competent, independent, and impartial authority of the judicial body. The safeguard shall be proportional to the degree to which such measures affect the person's rights and interests, not proportional to their disability and the severity of the disability, proportional to the degree to which the measures affect their rights and interests. And then lastly, subject to the provisions of the article, states parties shall take all appropriate and effective measures to ensure the equal right of persons with disabilities to own or inherit property, to control their own financial affairs, to have equal access to bank loans, mortgages, and other forms of financial credit, and shall ensure that persons with disabilities are not arbitrarily deprived of their property. Next slide, please. So I'm going to ask us to go to the one on the disability protocol. Next slide, please. Just a bit more. There we go. So when you start looking at the disability protocol, you'll see a lot of familiar wording. Equal recognition, appropriate and effective measures for legal capacity recognition. But now, Article 7.2b has an innovation. It says, no state actors and other individuals should violate the rights to exercise legal capacity of persons with disabilities. So that includes justice officials. That includes family members. That includes everyone, really. Non-state actors and their other individuals should not violate the right to exercise legal capacity by persons with disabilities. So when we say non-state, does that mean that the state can violate the right to exercise legal capacity? No, that's not what it's saying. It's trying to provide an emphasis of the context in which it happens. Because the first clause said recognition equal before and under the law, entitled without any discrimination to the equal protection and equal benefit. So it is simply an illustrative example so that we see how far the reach of recognition of legal capacity goes. And then there's another innovation. Subsection C says, not only should they be provided with support, but also effective legal protection to enjoy legal capacity consistent with their rights, will, and specific needs. Okay? And then appropriate safeguards, of course, this is quite similar. Next slide, please. And then another innovation, policies and laws which have the purpose or effect of limiting or restricting the enjoyment of legal capacity should be reviewed or repealed. Authority, that the status quo cannot continue. Another innovation, persons with disabilities have the equal right to hold documents of identity and other documents that may enable them to exercise the right to legal capacity. A couple of years ago, I was in a situation where a psychiatrist and an occupational therapist wanted to have inter-transdisciplinary conversation around mental health. And the psychiatrist's position was, what we really need to do to help my patients is we need a medical certificate that simply certify that the person is incapacitated. No? It's basically just like an endorsement on your ID. You just need the certificate, and that will help you to make my patient's rights protected or interests protected. It was a very big battle to explain to the psychiatrist, we can't just have this certificate that now deprives the person of the mental capacity that people can rely on in various situations. You're trying to do good, but you're doing harm. And then the same right to inherit property and not be dispossessed of it, and the same controlling their own financial affairs and equal access to bank loans, etc. Next slide, please. So you can see the innovations are specific emphasis that the violators are not just the legal system and state officials, but also non-state actors and individuals, which includes family members potentially, charitable organizations, and harassment that people face when they're trying to live their daily lives. That not only support is expected, but also legal protection to exercise that support. And this is where many countries are struggling because they want to know, okay, well, sometimes someone needs a little bit of support in daily decision making. How formal do we have to make those arrangements? Well, if you put safeguards in place, informal arrangements can of course continue. But that would also expect you to have champions and allies and ombuds that the person can go to and peer support networks when that informal arrangement is problematic. Those safeguards need to be in place so the person can bring a complaint, or there could be other avenues of alternative resolution so the person's voice can be heard. And of course, the formal processes. So South Africa is still stuck, aren't we? We are still stuck because we have a curatorship system, and then our Law Reform Commission said, okay, so we hear you, we need to change. But what we're going to do is we're going to keep the existing system in place, and then we will have a parallel process. Initially, we called it assisted decision making, and then someone was support. So now we call it supported decision making, right? And that bill is still stuck in the system. Now we have the Law Reforms Commission's domestication of the CRPD, very grand gesture, which will require us to obviously reform our court rules and legislation that talk about idiots and imbeciles. And that's cosmetic level, but also large-scale changes to mental health, education, social welfare, all of these fields. Okay. So I'm very cognizant of time. I'm just going to have a couple of minutes more of conversation because I think we don't need to go into all the legalities around what these concepts are. So the systems that you are working within, is there anyone here other than the SUTU who has made great strides in relation to putting in place alternatives or repealing the substituted decision making and recognizing legal capacity? Not just in a clause in the Persons with Disabilities Act that says everyone has legal capacity, but then subsequently we claw back by saying, oh, our Mental Health Act is so progressive, we're not there yet. What good practices do we have? What can you share with us? So we have a variety of options to choose from. We can have these framework legislations that says everyone has equal legal capacity for the law. Okay, we could do that. How far does that stretch? Who still has curatorship systems? Plenary guardianship. Raise your hands. Curator ad litem, curator bonus. Okay. Okay. Anyone here have guardianship proceedings? I'm talking about children who were orphaned. Guardianship, conservatorship. And if you are having today's conversation with your legislators, would they be open to the conversation? Or do you think they would need an absolute cultural awakening to what is actually required for equal recognition for all. And that accessing the justice system is premised on recognizing legal capacity. How are we going to proceed with that legal cultural awakening process? Okay.
It is very difficult, like you said. I don't know, maybe you will need all of us to die and then start afresh.
I'm back experience.
A simple concept like a person who uses a wheelchair does not equal to incapacity to parent. It's when you speak to other people, it's like they cannot imagine it. So you first have to convince them to be in line with that concept so you can get the proper report and the proper measures and the proper support. It is a battle. It is an uphill battle.
Okay, so we are not advocating for a large-scale dropping on the ground and perishing. There was just making a metaphorical example. Just to be clear, I saw a hand somewhere here. Yes.
Yeah, definitely, I support you on that. I think for me, I want to revisit a comment I made yesterday. At the end of the day, I think I was discussing with someone who was saying, I wish this discussion would target the highest policymakers in our systems. I'm not about a meeting like this one where my Chief Justice is sitting, where my Director of Prosecutions is sitting, where the Director of Correction Services or those people that make decisions are able to listen to this conversation. Because for me, the stigma starts there. The stigma starts there. Once it is there, it is like almost institutional. But once those people have gone through these discussions, have been exposed to these kind of possibilities, I think the trickle down effect will be very, very easy. Because it is to my secretary or the head of probation that I go and tell them, this is the discussion. But because of non-exposure to that kind of discussion, I've got to do a lot of work on this. So one of the proposals would be, could we think possibilities of just targeting people at our highest institutions and then bring them to this kind of profession? For me, that's my biggest issue.
So we have two proposals, and they are mutually supporting. Bottom and top, simultaneous. Because persons with disabilities should and genuinely remain in communities that support them. They have relationship of dependence on people that they have in their network. And those people also need to be really culturalized into the paradigm shift of legal capacity. But at the highest decision-making levels, it does need to trickle down, but I also want to propose to you that many people in this room have a lot more power and agency than you realize. Because a lot of discretion comes with your role. You are the allies and the champions. You are the ones who can have conversations in your war rooms, at your judges' conferences, at your magistrates' commissions. When you're interviewing someone for a position for the bench, are you asking them about their approach to disability? Are you asking them, do you utilize dehumanizing words in your judgments? Do you, as the Constitutional Court of South Africa, say the person is mentally afflicted and the person must be obtain treatment without their consent until they no longer have a mental disorder? What does that mean?
Thank you. I just wanted to agree with her comment of how to use all that. This is because I'm talking with God yesterday about a horrible example in Kenya, where the Supreme Court judges last year in Kenya found that one vehicle was mentally incapacitated to carry out our because of mental health issues. So even as we discuss that we need judges and the director of prosecution here, you can clearly see this is 2023 we are talking about. Kenya, my country, is one of the countries that has signed the ADP, yeah? And we think that by virtue of that there is the awareness, the understanding of what capacity is from the bench. But it is the bench that choose one of their own. So you can argue this is a lot. And I like what you say. It's us who are here, we have that power. So probably even as we go home tomorrow or as we discuss later, that's going to actually take hold. Because for my country, from Zambia, we can clearly see there's a lot of work to be done when we're discussing the capacity and the population of mental capacity. So I know I'm not bringing in solutions, but I'm just sharing the experience of, yes, these dialogues need to continue, and we do need to reach out further, but probably start from us here, and maybe there'll be a change done.
Starts with me. I'm going to have one more comment, then I'm going to close up because we've got running out of time. All right, Sophia? Yes.
Thank you. I just wanted to also add on the issue of like the power that we have to make change. To start with, it should start with us making the changes in the way we are talking about these issues and the way that the acts are also representing or talking about the people with disability, especially like I say in my country, we're still using words like MSL, which is very unfair. It should really change. And I could also agree when he said that people like the judges and those who are high up decision makers, for instance, in my country, as a magistrate, it is considered as a court with no record, which sometimes those judgments made in the magistrate courts are not considered. But I just remember we had a meeting, it was of course a different issue of trafficking persons. And we had judges who were also available in that particular meeting, and they were talking about issues like magistrates usually consider themselves as having less power, but they have more power because, like in my country, every case that is decided in the magistrate's court, it still goes to the High Court. Even if it's not appealed, it will still go for review, and they look at what you say in that judgment. So if you face things like maybe social workers were not up to their task when they're bringing issues in court, you always have to write that down in that judgment and make an analysis that when the judges in the High Court read that, sometimes they maintain that decision and then it goes out to the public, and that's how you influence the change in the community. So it starts with us. We don't have to consider ourselves that like we're not able to make decisions, but those decisions can clearly make a difference and changes in the laws. Thank you.
Round of applause for that suggestion. Unlike if they are meeting with you in the children's courts and you make a determination, you don't have to write the reasons for your decision. Oh no, you just simply tick a box, right? Okay. So we have a lot to learn. So I think I lost my train of thoughts, but in conclusion, we can see that we have a variety of options. Some are softer approaches of advocacy and activism, and some, of course, have to go very high levels. Our law reform processes need to be informed by this kind of cultural shift and range to see persons with disabilities. But also, we need to be very much aware that in this room, there's only a small minority of persons with disabilities speaking. And out there, the legislators and the judges are not hearing those voices. So we need to create the platforms that those voices not just create, but support platforms where it already exists and amplify those voices so that it is no longer nice to have, It's not a parallel to, because we want to comply with the CRPD, so let's just make some, cosmetic changes. No, it has to be real change. And we have a lot of power, but the status quo has to change, and that's why at the upper echelons there's also need to change. So I just want to say thank you for your participation, and I think we can give all of us champions and allies a round of applause.
Thank you both for the insightful presentation. So with this, we'll move to the next presentation, which focuses on issues related to access to justice, accommodation, and accessibility. So that's presentation will be made by Dr. Diana. Just to briefly introduce Dr. Diana. Dr. Diana Misipa is a disability and human rights legal scholar and advocate with research interest in a number of areas, including sexual and reproductive health and rights, access to justice, legal capacity, disability rights, protection in the Africa human rights system, children with disabilities, and the rights of persons with disability, albinism. She is currently the manager of the disability rights units and a postdoctoral fellow at the Center for Human Rights, Faculty of Law, University of Pretoria in South Africa. She also works as an independent consultant on disability and human rights law and policy, providing technical services to governments, departments, and civil society organizations. Dr. Diana teaches African disability rights protection as postgraduate level at the Center for Human Rights. She is also an assistant editor of the academic journal, the African Disability Rights Yearbook. Dr. Diana is an author with numerous publications in peer-reviewed journals and books, including Springer, Psychology, Law and Public Policy, Jackson, Law Review, the South African Journal on Human Rights, and the African Disability Rights Yearbook. So with this, I hand over the floor to Dr. Diana Misipa, who will take us through our presentations. I hope, Doctor, you will make it within 40 minutes. Hopefully.
Thank you very much. Yes, I will try to keep it within 40 minutes. I've timed myself so that I don't go over. A very good morning to everyone. I hope you're all doing well. So as Bernard has said, I'm going to be speaking about the concept of accommodations and accessibility. I think this mic is cutting off, I might need a different one. So the aim of this talk is simply to clarify what the obligation is, what the state obligation is in the context of access to justice. That is the aim of this particular presentation. Thank you. And I think in order to do that, we need to make a distinction between two related concepts, both of which are central to the idea, to the accessing equal justice for persons with disabilities. And these concepts are accommodations and accessibility. So the way that I'm going to present this is that I'm going to first speak about the difference between reasonable accommodation and procedural age and gender appropriate accommodation. From there, I will talk about the distinction between accommodation and accessibility, and then I will conclude by talking about which way forward in terms of access to justice. So starting off with reasonable accommodation versus procedural and age and gender appropriate accommodation. So many of us already know from our work that the idea of accommodations is central to the right to access justice. How do we know this? Because the CRPD and the African Disability Protocol say so. Article 13.1 of the CRPD talks about procedural and age-appropriate accommodations, and Article 13.1 also of the African Disability Protocol talks about procedural, age, and gender-appropriate accommodations. But I wanted to highlight a distinction. The CRPD as a whole and the African Disability as a whole talk about accommodations on two levels. There's reasonable accommodations, and then there is procedural and age-appropriate accommodations. So the two concepts are very close to one another, and consequently are often conflated. But there is a key distinction between them, which is essential for practice. So in practice, that distinction is crucial. It's not just an academic distinction or an intellectual distinction. It is crucial, and you will see in a few minutes what I mean by that. So I will start by talking about reasonable accommodation. So reasonable accommodation is a cross-cutting obligation. What I mean by this is that it is an obligation that states must fulfill in relation to several human rights. For example, education, employment, health, liberty and security of the person, and many others. So it is a cross-cutting obligation that is found both within the CRPD and the African Disability Protocol. On the other hand, we have procedural, age, and gender-appropriate accommodation. Now, this one is only applicable to the right to access justice. If you search both the CRPD and the African Disability Protocol, you will only find procedural and age-appropriate accommodations mentioned in respect of access to justice. They don't appear anywhere else. So they're only applicable to the right to access justice. The African Disability Protocol adds the gender-appropriate aspect, right? The CRPD only talks about procedural and age-appropriate accommodations. The African Disability Protocol talks about procedural, age, and gender-appropriate accommodations. So, for us to see what exactly this difference is between the two, I need to take us back to the definition, the CRPD definition of reasonable accommodation. And this is a direct quote from the CRPD. It defines reasonable accommodation as necessary and appropriate modification and adjustments. Highlight necessary and appropriate, highlight modification. So not imposing a disproportionate or undue burden where needed in a particular case to ensure to persons with disabilities their enjoyment or exercise on an equal basis with others of all human rights and fundamental freedoms. In short, these are the components, the two components that are important of the duty to reasonably accommodate under the CRPD. Okay? Under the CRPD, not the African Disability Protocol. So the two components, the first is the single term reasonable accommodation. Okay? So in the past, I think we used to think that reasonable and accommodation were different, right? One being a qualifier and the other one defining the concept of what an accommodation is. But if you read through the jurisprudence and the general comments of the committee, the Committee on the Rights of Persons with Disabilities, which is the treaty body whose job it is to interpret the CRPD, they say this is a single term and these two words must not be separated. So they say it's a single term reasonable accommodation, and what it refers to is necessary modification needed in a particular case to ensure human rights. Okay? If it is a modification and if it is necessary for the purposes of ensuring human rights, it is a reasonable accommodation, right? That's what that means. The reasonable part of it speaks to relevance and appropriateness and the effectiveness of the particular accommodation that is sought, okay? Then the second component of the duty to reasonably accommodate is disproportionate or undue burden. So this essentially limits the duty. So it's not a limitless duty, right? You don't have to provide every single accommodation that is asked for. The duty is only to provide an accommodation that does not impose a disproportionate or undue burden, right? So how do you determine whether there's a disproportionate or undue burden? So this decision is based on considerations such as the cost involved for providing the particular accommodation and the available resources that the duty bearer has. Okay? So it's a proportionality, there must be a proportionality between the means employed and the aim of providing that particular accommodation. Okay? So those are the two components of reasonable accommodation. Then let's look at the components of procedural, age, and gender appropriate accommodations. The first component is that of accommodation, and again, it is talking about necessary modifications or adjustments that are needed in a particular case only for purposes of ensuring the enjoyment of human rights. The second, the part about procedural, it is concerned with procedures and processes in the justice system. And age appropriate talks about adjustments or modifications that are appropriate for one's age. So for example, if you're providing accommodations in relation to access to information related to access to justice, if your witness or your complainant is a child, then the information that you give them must be pitched at the level a child can understand. So that is what we're talking about when we say age appropriate. And then the other component is gender appropriate. And this is only from the African Disability Protocol. And this is speaking about adjustments or modifications that are appropriate for one's gender. So what is the distinction then between reasonable accommodation and procedural accommodations? This is the major distinction. Procedural accommodations may not be limited by the concept of disproportionality. So, in other words, there is no requirement for anyone to prove or that this imposes a disproportionate or undue burden. So that whole cost-benefit analysis that is applicable to reasonable accommodation is not applicable to procedural accommodation. So in terms of access to justice, whatever accommodations are required in the access to justice sector need not be subjected to the test of proportionality. The duty bearer does not have a defense to say, I don't have to provide this accommodation because it's too costly. In the context of access to justice, that is irrelevant. That cost-benefit analysis is only relevant to reasonable accommodation, which is applicable to all other rights except access to justice. For those of you who want to check out, who want an authority for what I'm saying, take a look at General Comments 2 and 6 of the Committee on the Rights of Persons with Disabilities. General Comments 2 and 6, okay? And then the other distinction between the two concepts is that there is no requirement when it comes to reasonable accommodations. There's no requirement for reasonable accommodations to be age and gender appropriate. That has been specifically included, right? But I think in practice, it simply makes sense to think about accommodating someone in a manner that is age appropriate, in a manner that is gender appropriate as well. So this distinction that I mentioned, so I'm drawing a distinction between reasonable accommodation and procedural accommodation in the context of the CRPD. Is anybody lost at this point? We're still together? Okay. The reason why I emphasize that this is the distinction between reasonable accommodation as understood in the CRPD, right, is because the African Disability Protocol may actually be an exception. Why do I say that? Is because if you look at the definition in the African Disability Protocol for reasonable accommodation, it does not make mention of the proportionality test. It reads as follows. This is Article 1 of the African Disability Protocol. So reasonable accommodation in the African Disability Protocol means necessary and appropriate modifications and adjustments where needed in a particular case to ensure to persons with disabilities the enjoyment or exercise on an equal basis with others of all human and people's rights. So there's no mention of they must not impose a disproportionate or undue burden. So when it comes to the African Disability Protocol, there is no distinction between reasonable accommodation and procedural accommodation. The only distinction in the context of the CRPD between those two concepts is the idea of proportionality between costs and aim, right? So is it clear the distinction that we have between the reasonable accommodation and procedural accommodation? Why is this important for us to know in the context of access to justice? It's important because if we are relying, for example, on a CRPD understanding, I think essentially in practice it will come down to which of the two state parties decide to domesticate. If the instrument, for those that are dualist states, the instrument that domesticates, the local instrument domesticates the CRPD and takes the CRPD understanding of reasonable accommodation, then you should know that this cost-benefit analysis does not apply, okay? So it's important to know that. When it comes to accommodations in the justice system, it does not matter whether it's costly, the duty is there, that it must be fulfilled. So the other distinction that I want to draw between concepts that are related, closely related, is the difference between accessibility and accommodation. So accessibility is relevant and important for access to justice. For example, when we talk about physical accessibility, this is talking about entrances to a particular building, lifts, bathrooms, etc., etc. So physical accessibility, police stations, courts and prisons, and any other building that is used for the administration of justice must be physically accessible. And then accessibility in the context also of accessible information. What this means is that charge sheets, witness statements, wounded portion statements, etc., must all be accessible in accessible formats. Several accessible formats that were mentioned yesterday. Does anybody remember some of them? Braille. Braille. Easy to read. Yeah. Sorry. Yeah. Electronic format is also an access issue. Yes, you're right. Why? Yes. It opens up the possibility of someone using a software like JAWS in order to convert text into speech for people with visual impairments. Yes. Okay, yes. So that's accessible information. And then there's also accessible transport. All of us know that, when trials take place, some witnesses have to travel long distances. And if we're talking about a witness or a complainant or an accused person with a physical disability, transport has to be accessible, right? Transportation has to be accessible. So accessibility is an important one for accommodation, for access to justice rather. So then what are the differences between accessibility and accommodation? So accessibility, the concept of accessibility relates to groups, and accommodation relates to individuals, okay? The second distinction, accessibility is an anticipatory duty. What does this mean? This means, let's say, for example, you're building a new court building. I think we had this discussion yesterday. Accessibility, the duty to provide accessibility dictates that you must anticipate beforehand or in advance what needs you're going to have. The accessibility needs that different people are going to have. So that means you must anticipate that at some point there's going to be someone who uses a wheelchair that will require access to the building, that will require access to facilities like bathrooms in the building, etc., etc. And it is required that right from the beginning, you make arrangements to make the building accessible. That includes signage, that is not just in text, but also signage in Braille. I've seen elevators that have Braille signage so that if somebody walks in, they know which floors based on the Braille signage in that particular lift. So accessibility is anticipatory in nature. Then accommodation is responsive or reactive. The duty to accommodate only kicks in upon request. So when somebody walks in and says, I have this particular need and I need to be accommodated in this way, that's when the duty kicks in. Okay? So accommodation is a responsive or reactive duty. And then the third distinction is that accessibility is intended to be implemented gradually, whereas accommodation becomes enforceable immediately at the point of request. So with accessibility, we were talking yesterday about court buildings, how people are maybe making changes to some of the buildings, but then there's still other buildings that are not yet accessible. In terms of accessibility, that's acceptable because that is the progressive realization right? So that right is to be implemented progressively, at a gradual pace and over a period of time. Whereas accommodation, the minute someone says, I have a trial next month, I'm standing trial next month, and I need a sign language interpreter. At that point, you can't say, okay, we'll get you a sign language interpreter next year. The duty becomes enforceable immediately as soon as that request is made for access for accommodation. So which way forward for access to justice, right? So in terms of access to justice, both accessibility and accommodation are relevant. Both those rights are relevant. But because the CRPD and the African Disability Protocol talks about accommodations specifically, right? I think it's important for us now to spend the rest of the time that I have left talking about accommodations in the context of the justice system. So there are many accommodations that can be made in the justice system, and all of them depend on the person's type of disability, the specific needs that the individual has. So accommodations are individualized, they are specific to a person's individual needs. Broadly, I generally, and I think other people as well, categorize them under two different categories. So there's accommodations that can be made to the environment, and there's accommodations that have or concern communication, the manner in which someone communicates their evidence, whether they are a witness or an accused person. So accommodations to the environment are easy to understand because these are, remember what we said about accommodation, it's any modification. So these are modifications that are made to the external environment in which someone is giving evidence. Examples of accommodations to the environment include conducting interviews outside the police station and in plain clothes without a police uniform. So which persons with which type of disability might need this kind of accommodation? Mr. Mandipa?
I think persons with intellectual disability.
Persons with intellectual disability. Can we roll the mic? Okay, yes. Would you like to explain? I'm not putting you on the spot, but if you have an explanation, yeah.
Okay, thank you. Think from yesterday, you really made it when you were defining what intellectual disability is. It is actually something to do with the development of the mind. So most of the time, you might find that possibly victims with intellectual disability might be, say, fearing the police uniform, or even fearing the police station itself. But they might think that maybe to visit the police station, you are the one who's doing up, maybe in the holding cells. Yes, so I think we need to have data outside the police station so that we allay those fears.
That's right.
And they can open up.
So what happens if we don't allay those fears? So, yeah. Anyone else?
You're not going to get what you're looking for.
Yeah, you're not going to get what you're looking for. The communication that you need, right? So the justice system is dependent on communication. Everything that happens in the justice system is about communication. It's about how the question is asked, how someone answers a particular question, right? So if, even for us, if you are taken to a police station, even when you know you didn't commit a crime, there's just something about a police station that is unnerving, you know what I mean? So one of the things that we do is make accommodations in the environment to ensure that the environment is conducive for effective communication to take place, right? Another accommodation to the environment is having a support person present during interview. During like a police interview or an interview with the prosecutor, just having a support person present. So the support person is someone who really just is there for moral support. They don't say anything, they don't contribute, they are just there. Their presence is meant to be a comfort to the person who's being interviewed. And then there's preparation for appearing in court. Court preparation, I think generally prosecutors do this for a lot of witnesses, not just witnesses with disabilities, but I think it's even more crucial for witnesses with disabilities. What does court preparation involve? Yes.
It involves explaining the process to the witness. For example, what's going to happen in court, where they're going to stand, who's going to ask them what's the purpose of those questions, just to make them familiar with the environment.
Okay, perfect. Why, just a follow-up, why would we want them to be familiar with the environment?
All right. I'll take it from an aspect of dealing with children. Usually when people scare children, they'll scare children with police. You get arrested if you do this or that. So it's very important to explain to them that you are not in trouble. If you say what's happening and if you made a mistake, you're not going to get arrested for it, or you're not going to get punished for it. So that they're at ease to tell their side of the story.
So it's all about, again, attempting to facilitate effective communication, right? And also establishing a rapport with the prosecutor, because in the criminal justice context, if you are the complainant, the prosecutor is your lawyer. They are representing you as the complainant. There's also giving evidence via closed-circuit television. There's also taking extra breaks. There's persons who cannot concentrate for extended period of time, and they need, after a certain period of time, they need to take a break. After a certain period of time, they need to take a break. That is an accommodation which they must give. In order to determine, how do we determine when to take a break? When the witness needs a break? Yes.
Thank you. I think you determine that during the preparation stage, the court preparation stage, and when you are speaking to your witness, you realize where the barriers are. And if there's a support person as well, they are able to tell you where the barriers are and what you need in order to safeguard that witness.
Yeah, that's right. And also the witness can tell you, you just ask, do you need a break? They will tell you, yes, I need one, or no, I don't need one. Yeah. So there's many ways of trying to determine how often someone needs a break or when someone needs a break. Sometimes you can tell from their reaction to things that maybe their attention is now divided. You can just tell and discern that maybe it's now time for a break. Okay. And then another accommodation, and this would be for persons who are visually impaired, is to describe who is in the room, describe the room itself, who else is in the room, if it's an interview in the police station, tell them I'm here with my colleague so-and-so, or it's just me and you in the room, explain what the process is going to be, and something that Mr. Maka mentioned yesterday is having as few disturbances as possible during an interview. And sometimes even something as simple as changing the seating arrangement in court is also incredibly powerful, putting someone at ease so that they are able to give their evidence freely. So there's an issue of credibility that was brought up yesterday. I think somebody asked about it. So one of the things that we ought to remember is that credibility is not 100% in the individual, right? we try to think of credibility as this person is credible or they are not credible. One of the ways credibility is determined is consistency of account. If your account is consistent, a witness's account is consistent, then generally people conclude that this is a credible witness, this is a reliable witness. But is it always the case that the reason you get conflicting accounts from a witness is because the witness is lying? Is that always the reason for conflicting accounts?
No.
Okay, anyone care to? Yes, Dr. G.
From my experience, most of the time, witnesses, particularly with psychosocial and intellectual disabilities, are not being given an opportunity to tell an account of their story. They are written on only an account of their disability. So I find that when judge or magistrate is given a person a case, it's because they're using their own common law provisions on who can testify in court, period. I think when a witness is given an opportunity, a witness with alleged disability is given an opportunity to testify, and there's consistency in their testimony, there's generally that latitude to take into account the evidence. So I think that the issue should be to them really just give them opportunity to speak and to testify.
Yeah. Anyone else? I saw another hand. Okay. Tamazai and Bianca. Okay. Bianca, you have the mic first, so you can go.
Okay, also I think what causes I just think that there's a confusion because of the language used between the court itself, and then we are speaking in English, and that the English, the court English is being translated or interpreted, and the interpretation that comes back is something else. So I just think that there's just a massive confusion going on.
Yeah. Yeah, that's absolutely true. So this brings us to the second type of accommodations, right? So these are accommodations to do with the language that the witness uses and that other people use as well in the case. So these accommodations touch on the communication, and they also touch on the content of someone's evidence. So they are concerned with the way a person understands and conveys their account and how they respond to questions. So these accommodations are usually made for people with disabilities that have an impact on cognition and or communication. I'll give you examples so that you understand. So these are examples of some accommodations that can be given to someone with limited language skills. Okay? The first is the use of anatomically correct dolls. We all know what those are, right? So these are just dolls with the correct anatomical parts of the human body. The male doll has all the correct male anatomy, and the female doll has the correct female anatomy. So they are used to augment language, verbal communication, right? So if someone they can speak, they are verbal, but perhaps because of their disability, their vocabulary is limited, or they have limited language skills, then you can augment using tools like anatomically correct dolls. So I'll give you an example of an intermediary who was pulled into court, the police station rather, and they wanted to get evidence from a witness with an intellectual disability who was alleging that she had been raped. So this particular witness, complainant rather, belonged to a community in Israel that is known as the Bedouin community. They have a specific traditional dress where the men wear, I don't know what they're called, turban? I don't know if that's the right word. But they have like some kind of headscarf, and then there's a robe that men wear with trousers inside. So the girl was given the doll to explain what had happened. So she was saying some with words what had happened, but she also was asked to demonstrate exactly what had happened, how the accused person raped her, how he paid, etc., etc. And the girl took this doll, but the first thing that she did is she put the head thing, you know. So this means that she was not just doing a generic, but she was actually associating this doll with the accused person. So she first dressed this doll like that accused person. And then she took the doll's, the inner trousers down to just above the knee and said, this is how we did it. So that's one way of augmenting communication. The other way is the use of pictures. So I'll give again an illustrative case. In this case, I call it the lollipop case. What had happened was that the complainant, again, was a young girl, a schoolgirl with intellectual disability. And she had been forced to perform oral sex on the school bus driver, the bus driver that drove her home from school. So when she got home, she reported to her mom that the bus driver gave me a lollipop. So for the mom, it immediately made sense what she meant, because the mom was the one who had told her to refer to the male genitalia as a lollipop. But now at the police station, the police was like, we need to establish what she means, because it's not a crime to give someone a lollipop, right? So there's a need to establish what she means, but she did not have the right vocabulary for the male genitalia. So because there was an intermediary, they had spoken to the mom, and the mom had testified that I'm the one who taught her to refer to it as that. And the police were like, we need to get it from her, that this is what she means when she says. So the communication facilitator presented the witness with a number of pictures. So the pictures were arranged according to, there were pictures of different foods, okay, including the sweet, the lollipop itself. And then there were pictures of different body parts. Hands, legs, etc., including a penis, right? And then they put these pictures, mixed them up, put them in front of her and said, point to the lollipop that the bus driver gave you. And instead, the lollipop, the real sweet, was there. It was one of the pictures, but she pointed at the penis, and that's how they were able to determine what she meant by lollipop. There's also the use of an alphabet or a letter board for someone with limited language skills. So I think this one is more for someone who is completely nonverbal, where they can, especially if they are also have a physical impairment, where they can use a letter board to spell out essentially what they want to say. Like if you want to determine from the witness, where were you or who did this, you give them a letter board, and then they can point to the letters and spell out what it is they want to say, assuming they are literate. Okay. Persons with intellectual disabilities may also have difficulty understanding and communicating concepts such as time, quantity, and space. So why is this particularly problematic in the criminal justice context? Fayal. Maybe you can just project. Yeah.
It's because they need to say specific dates and times, so they'll be asked to talk about specific dates and time, and things like this, and they won't be able to do that.
Yes. So for example, if an accused person, his defense is an alibi, and says, at this particular time, I wasn't even there. So it's important for the court to establish the date an event took place and the specific time. So if persons with intellectual disabilities have difficulties with these concepts such as time, quantity, and space, what do we conclude? Do we then say, they're unreliable witnesses, let's not even use them because they can't even articulate the time? No, you accommodate. She was a woman with an intellectual disability who was institutionalized. She lived in an institution. And so she had been raped by one of the staff members in the institution. But there was a little bit of contention, and it seemed like she was inconsistent about the time that the rape occurred, because she was saying that she was raped at 6 o'clock at night. That was the language that she was using, the terminology that she was using, 6 o'clock at night. But with the evidence from the other witnesses and other evidence in the case showed that the rape had actually happened at 6 o'clock in the morning. Right? She was inconsistent about the time. She was saying 6 o'clock at night. There was other evidence that suggested actually it was 6 o'clock in the morning. So what the intermediary did in this case is try to explain to the court, was to establish how the particular witness understands time for herself. Right? So we understand time in terms of it's now 11:23 in the morning, etc., etc. But she, because she had been institutionalized for so long, understood or ordered her day according to the staff shifts. So she was raped during the night shift, which started at 6 o'clock in the evening and ended at 6 o'clock in the morning. So once they established what she meant it was 6 o'clock of the night shift. So essentially, her evidence was not actually inconsistent with the evidence of the others. It was just her expression of it was according to how she understood the concept of time, how she ordered a day according to the shifts, the start shifts, rather than the clock, the time that we have for the clock. In another case, I'm out of time, so I'll just skip some of the cases. In another case, let's talk about the gym case, okay? So in another case, the woman with an intellectual disability was raped in a gym by the gym instructor. That was her allegation, that was what she alleged. So one of the things that the defense counsel was trying to attack as usual was her credibility, right? So during cross-examination, he gave her a sheet of A4 paper. On that sheet, he drew a rectangle and drew a map, marked X on one end and Y on the other end. And then he said, they put a key and said, X means the door, Y means the corridor. And he gave her that piece of paper and said, can you mark on this piece of paper exactly where you were in the gym in order to show us exactly where you were raped? And she marked the spot. And he moved on, he asked some other questions, and then he came back to that question and said, remind me again on this map exactly where you say you were. And she marked a different spot. So then he was saying, so this didn't happen, because you don't even know exactly where you were when the alleged rape took place. So the intermediary again was able to make an intervention that the problem might not be that the witness doesn't know where she was when she was raped. The problem is with the tool that the defense counsel is using, the map. It's too conceptual. So it requires her to imagine that a rectangle on a paper is the gym, and X is the door, and Y is the wall that faces the corridor. That map was too complex for the witness. And so what the intermediary suggested is that the court go to the gym with her and ask her, where exactly in this gym were you when you said that he raped you? So the positioning was important because that gym was built in such a way that the corridor, on the corridor side of it, the wall was glass. So the defense counsel was trying to say, if it's glass from ceiling to bottom, people that were passing in the corridor should have seen the rape taking place. So that was why that particular line of questioning was important. But the intermediary was able to guide them and say, yes, it's important, let's not abandon this type of line of questioning, but let's use it in a way that let's accommodate the witness so that they're able to, by eliminating things that require conceptualization of abstract things like that. Okay, so I had other examples, but I think for the sake of time, I'm going to stop here and just do my last slide, which talks about the purpose of accommodations. So within the criminal justice system, why do we provide accommodations? So accommodations are intended to enable persons with disabilities to participate in the criminal justice system on an equal basis. The idea is not to give them an advantage over others, but it's just to level the playing field. We are not intending to relax the rules of criminal procedure and evidence in the favor of persons with disabilities, but we recognize that they are starting from a position of disadvantage, and we just want to level the playing field. For that reason, success in providing accommodation is not measured by the outcome of the case. You can successfully accommodate a complainant with disabilities to testify in a case and still lose the case. Why? Because the outcome of the case is determined by more than the evidence of one person. It's determined by the totality of the evidence in a particular case, and it's determined by the law, legal provisions, right? So success, then how do we measure success, whether we have successfully accommodated someone? We measure it by whether or not the complainant feels and actually did in fact have fair chance to give their account and to participate. If they did, they gave their fair account, participated effectively, you have been successful in accommodating them, regardless of the outcome of the case. So let me stop there. Thank you very much for listening. I think it's tea time, so let's take a break for tea and then come back to it.
By 1 o'clock, we'll have a new president.